Hello, everyone, and welcome back to Law and Democracy, a podcast of the election law program at The Ohio State University Moritz College of Law. I'm Tony Goggin, a senior fellow in the program, as well as professor of law and current family chair in law at Drake University Law School. And I'm joined by Professor Ned Foley of The Ohio State University Moritz College of Law. Ned is the Charles W. Ebersold and Florence Whitcomb Ebersold Chair in Constitutional Law, as well as the Director of Election Law at Ohio State. And I'm joined by Terry Enns, the James W. Shaughnessy Professor of Law and Senior Fellow at Election Law at Ohio State. And Terry, Ned, and I are so thrilled to be joined as our guest on the program by Dean Franita Tolson, the Dean of the University of Southern California Gould School of Law, as well as the Carl Mason Franklin Chair in Law at USC. Professor Tolson is one of the leading election law scholars in the country, as well as the Dean of USC. And we're very excited to have the opportunity to talk about her forthcoming book, In Congress We Trust, Enforcing Voting Rights from the Founding to the Jim Crow Era, which will be published next year by Cambridge University's Press, as well as any other topics in law and democracy that Professor and Dean Tolson would like to discuss. So with that introduction, I'm going to hand things over to Ned to ask the first question of Franita.
Well, and I too am just thrilled and delighted that we're doing this podcast with Franita. As some listeners may know, Franita and I go way back as podcasting partners when we had our own podcast, Free and Fair, with Franita and Foley, which I remember fondly and wish that the deaning allowed for that to continue. But I know that public service is an important part of what we do, and so it's just great that we can bring the band back together, so to speak. So let's talk about the book. I've been lucky enough to be able to see an advance copy of it, and it's really fantastic. Franita, you're such a beautiful writer. We've known that from reading your law review articles over the years, but to pull all of your scholarship and wisdom and together in this book, it's really great. So why don't you tell our audience just a little bit about the book and what motivated you to write it and what you see it doing?
First, let me just thank you both for having me on the podcast. And of course, Terry, it's nice to meet you as well. I think that, part of the motivation for the book was born of confusion. And as election law folks, you understand that the case law is a mess. The history is unclear on a lot of issues. And so, over the course of writing my scholarship, which really was kind of like at an intersection of different literatures. So I was writing at the intersection of common law and election law because I was really intrigued by the question of which level of government is responsible for regulating what. Right. So, generally we think about the states as regulating voter qualifications, and we think about Congress's authority as a little bit broader when it comes to election administration because of the elections clause. But there's so much overlap and ambiguity in those categories that it's often not clear, which is why we have, so many cases, at least, post Bush versus Gore on, where, the Supreme Court was trying to resolve these issues over state and federal authority that were particularly pertinent in the context of the Voting Rights Act. But I also had questions about separation of powers. We often talk about congressional power over voting, but we're looking to the Supreme Court to define what that means. And the court has kind of given itself a starring role in that. Remember, what's the case? Trump versus Anderson, the electors case. One of the things that the Supreme Court said in that case that stood out to me was that they were like, if someone is disqualified under Section 3 of the 14th Amendment and can't run for office, Congress has to pass a law. But of course, the Supreme Court gives itself the power to determine the constitutionality of that law, just by virtue of the fact of that's how it weighs in and that's how we accept their role. And so in many ways, the book is born out of frustration because there are just certain things about election law that we assume to be true. We assume that the Supreme Court is this kind of almighty overseer that determines the scope of power when it comes to the other branches. We assume that the states have a broad authority over elections that Congress is not really supposed to disturb, but in exceptional circumstances. And so the book is an attempt to try to figure out if that's true. Now, a third theme emerged in the course of writing this book. So it was not just about congressional power versus the Supreme Court. It was not just about the federalism issues, but also this question of what is the right to vote. So the book really does engage this question of, when we talk about voting rights, what are we trying to regulate in the first place? And so, just in trying to deal with those three themes, I felt like I had to start at the founding, which is why, the book tries to take a fresh look at the founding generation and understand some of the assumptions that went into what authority Congress has under the original Constitution when it comes to elections. And when we talk about the right to vote and who possesses it, what exactly are we talking about? So that's the general framework of the book. But the book, for your listeners, is called "In Congress We Trust?" Because it really does question this idea that, even if we accept that Congress is a separate branch of government from the Supreme Court that has broad authority, and in some cases judicially unreviewable authority, to regulate elections, that, there's still this theme in the book that sometimes Congress is really ineffective in exercising that power. And so, looking at this history, it really is contested and is fraught. And we may not have clear answers and, that sort of can resolve a lot of the issues we deal with today in voting rights, but we do have a lot more clarity, I think, once this book comes out about what that history is. Because I found a lot of gems that we just don't talk about. And when I've testified in front of Congress a few times, I was struck by the fact that many people in Congress don't know what Congress can do in this space because so many of these powers have lain dormant for 100+ years. So that's the general framework of the book, and I'm happy to talk more about the particulars. But I really want to invite scholars to have a conversation with me about if we should be talking about Congress the same way we talk about the Supreme Court when it comes to the regulations of voting and elections.
Yeah, that's great. And is it fair to say, just in terms of the big picture overview, that what you've discovered is that Congress has much more power than many people have thought, partly because the power that it has failed to use, and sort of it's lost its muscle memory, if you will, because it hasn't exercised the muscle that it could have if it had kept itself in shape. Is that a fair?
Well, that's the general takeaway, and one of the ways I try to make this case is by focusing on provisions of the Constitution that don't normally get a lot of attention. So we talk a lot about the 14th and 15th Amendments, but we talk about those amendments from the perspective. You can't have a conversation about Section 1 of the 14th Amendment without talking about the Supreme Court. But I found that you can have a conversation about Section 2 of the 14th Amendment and not really talk about the Supreme Court as long as you stay out of the 20th century. So, because Section 2 of the 14th Amendment, what we have, at least when it was ratified, was, Congress's intent to reduce a state's delegation in the House if that state abridged or denied the right to vote. It was never enforced. And so in the 19th century, you didn't really have any case law about it. But what you do have is congressional debates about what that provision was supposed to do and how they tried to enforce it. Right. So for me, that was a very powerful narrative about how Congress conceived of its own power, in a way that we don't normally talk about. Another provision I focus on in the book is the guarantee clause. The guarantee clause, every once in a while, it makes a renaissance, right? Because I think people are fascinated by this idea of what a Republican form of government is. But Reconstruction is an instance in which Congress relied on the guarantee clause in enacting portions of the Reconstruction program. And so I sort of look to those debates and those attempts to try to bring democracy to the South as a way of understanding the scope of the guarantee clause. I also talk about Article 1, Section 5, which gives Congress the ability to judge the elections of its members. And that is also a powerful source of authority that Congress has used to exclude members who were elected in races, for example, that were punctuated by racial discrimination in voting. And it's not a provision that gets a lot of attention nowadays, but during the 19th century, you saw a marked increase in the use of the Article 1, Section 5 power to try to, in some ways, beat the South into submission. Right? If you have these elections where people are discriminated against and there's violence, well, we won't seat the winner of that particular election. So looking at these provisions, they're notable because they're not provisions that we typically think of as having like a ton of Supreme Court case law. Right. And so right there, we're kind of shifting the debate away from the court and really trying to focus on, what Congress can do without the court sort of weighing in and bringing its own vision of democracy to bear on how the other two branches should sort of regulate elections in this space. And that's generally the hope of the book, shifting the conversation a little bit away from the courts. But there will be a second volume at some point where I feel like the discussion of the courts is inevitable. But then we can have a really, really interesting conversation about how we should conceive of the Supreme Court's authority in this area now that we know what Congress can do.
Well, I got a zillion more questions, but I want to let Terry and Tony get back into the conversation. So let me hold off my next question.
I just have a follow-up question for Anita. Your book is a history, and historical research is inherently filled with interesting discoveries. What were some of the interesting discoveries and gems you made reference to that you turned up that particularly surprised you or impressed you?
Well, one thing that really shocked me was how well documented the election contests were in Congress. Right? They had their own rules that govern the proceedings. In certain situations, they would decide whether or not to defer to state court pronouncements about whether or not a particular voting law was constitutional. There were situations in which Congress itself decided that a voting restriction was not constitutional, independent of the court, right? And so they made that determination, and then they decided how that impacted the election contest before them. So you really did have Congress in this judicial role in some cases that allowed them to resolve election debates, and that really, election disputes, and that really, really shocked me. And I think part of it is, in law school, it's all about the courts. You're conditioned to think about the courts. In our scholarship, we talk about the courts a lot. So seeing Congress, regulate and approach elections in this way, independent of the courts, was very shocking to me.
You briefly just mentions the state level, and since I deal a lot with the state level, can you say a little bit about what you what you found Congress vis-a-vis the state constitutions, state legislatures, and what they're doing?
So, it's interesting because I also, so I think I'm predisposed to think about federal power very broadly, right? When I was in law school, the focus was on the Warren Court, right? So you think about the Warren Court validating a congressional legislation that basically changed the complexion of the South, right? So the Voting Rights Act, the Civil Rights Act, you think about federal power as a good. And I think I went into this project thinking about it that way, even though my focus was on Congress instead of the court. But what this taught me is that the states still play a very, very important role in a way that I don't know if I fully appreciate it, right? Because the difficulty of having a federal government try to regulate the politics of the former Confederacy, it was a Herculean task. Right. So on some level, we have to have working state political systems that ideally work in cooperation with Congress in order to ensure that we have this inclusive brand of democracy. I do think that was maybe latent in what we see in during at least the initial stages of Reconstruction, right? I don't think Congress envisioned itself as having to engage in oversight of the South forever, right? What they hoped was that, and they used the guarantee clause in part to do this. They basically had the Southern states call new state constitutional conventions. These were some of the most, inclusive conventions in this country's history, right? You had black men and white men, not women yet. We're not part of the story yet, but you had black men and white men coming together to pass new constitutions that embraced a very broad vision of democracy for that time. Right. And these were the governments in the South that were supposed to govern moving forward. Right. So it wasn't even a situation where it was like the federal government was like, OK, we're going to come in and we're going to, be overseers of the South forever. No, the governments that were supposed to take hold in the South just didn't hold. But if we think about the original vision was that we would have state governments that embraced a broad conception of democracy that would be able to stand on their own 2 feet. And the fact that Congress had to continually intervene in the South was unfortunate. But I don't think at the time that they were trying to come up with this framework that it was expected. But I'll make a related point too. I do think the nature of the tools that Congress had at its disposal is one of the reasons why Reconstruction went on until the 1890s, early 1900s. One of the things I try to do with my narrative is challenge this idea that Reconstruction ended in 1877. Other historians have, kind of made this point that there were efforts in some parts of the South to keep democracy going, right? There were, I've read treatments where historians talk about the fact that African Americans continued to vote in parts of the South well into the 1880s and 1890s. But I think an important part of that story is that they were able to do so because Congress was still using its power under Article 1, Section 5 to try to keep people from being seated who were selected in these races that were punctuated with racial discrimination and violence. There were efforts to enforce Section 2 in 1899 and 1901, well after, there's this sense that Reconstruction ended. And there was also an attempt in 1890 to pass pretty comprehensive election legislation in order to address some of the disenfranchisement in the South. So even, post really 1888, you see a new crop of Republicans come in who are really aggressive about trying to, revive Reconstruction because, there was just this sense that post 1876 election, Reconstruction ended. But one of the things that the book tries to show is that the story is actually more complicated because, Terry, to your question, I think there was some sense that this is our last ditch effort to try to create democracy in the South so that the Southern states can stand on their own and the federal government does not have to keep coming back and trying to police this.
This history is so rich and important. Did you write an amicus brief in the pending Louisiana versus Calais case? And the reason why I asked that is having listened to I did not write an amicus brief. I did not participate at all in that case, but listening to the oral argument, I'm very worried that the Supreme Court is going to misunderstand the relevant history in terms of thinking about congressional power under the 15th Amendment. I think there's a serious risk that the court is going to just distort and, butcher, if you will, the truth about what the congressional power was supposed to be. I guess we won't know until we see the opinions come out, but I just curious whether or not there's a way to get the ideas and the knowledge and the research that you've done on the history in front of the court so that at least they're aware of it before they make their mistakes.
Yeah, I don't think they'll care. So I I didn't write an amicus brief. And part of it, so one thing I did agree to, I agreed to write the case comment for the Harvard Law Review. And part of the reason that I agreed to do that is because I did want to get some version of this history out there so that people understand that the way that the Supreme Court has conceived of discriminatory intent makes absolutely no sense. And it makes absolutely no sense in light of this history, right? Because one of the things I discovered, and towards the end of the book, the last chapter really is this study of what happened across the South in the 1890s. And I think 4 or 5 states to really go into detail about how African Americans were disenfranchised legally over the course of that decade. The shift to race neutral practices that many states in the South post 1890 actually put in their state constitutions. And, I wanted to, in its case comment, I wanted to talk a little bit about how that transpired in Louisiana, in part to show that discriminatory intent never really leaves. The method just changes, which I think instinctively people know, but the Supreme Court does not approach the question of discriminatory intent in that way. And we know that because of how the Supreme Court talks about whether or not discriminatory intent can survive a change in the legislature, right? The fact that discriminatory intent can be changed, can be extinguished if there's a new legislature who adopts the same law, or alternatively, if a law is reauthorized. Right, that was the Mississippi felon disenfranchisement case, right? This idea that, and that might just be a Fifth Circuit case, but this idea that because the law was reauthorized in 1968, that extinguished the original discriminatory intent from when the law was passed in the 1890s, right? That whole conception of discriminatory intent as being something that can be easily vanquished is ridiculous. Instead, what happens is anytime a law is struck down as unconstitutional, The state legislature just figures out a different method in order to mimic the effects of that law. And what the 1890s taught these state legislatures is that they can do it through race neutral means. But the Supreme Court just simply doesn't think about it that way. And even more pointedly, if you look at the facts of Calais, what you have with the Louisiana legislature is they're actually using the Supreme Court's framework in order to get their own plan invalidated, right? So this is why they talk about race so much in the legislative history, because they know that that provides evidence of racially discriminatory intent for Supreme Court purposes that'll get that map struck down. And so that's just another situation in which the state legislature just adjusts in response to either a law being invalidated or a change in the Supreme Court's doctrine, right? But our understanding and the way we discuss discriminatory intent has not changed. And it's just very weird to me.
So do you have any, again, I want Tony and Terry to jump in, but do you have any recommendations about what we can do given, if the court is going to ignore the truth about history and sort of do its own thing, can Congress get some of that muscle memory back and kind of, be confrontational with the court and not just take it lying down? Or, I mean, what can we do to get out of this difficult situation?
I actually think the question of what we can do is a hard question, right? Because part of it has, so in some ways we're shackled by our success. The Voting Rights Act, let's talk about the Voting Rights Act. The Voting Rights Act is the most successful piece of legislation probably in this country's history when it comes to just completely changing the political makeup of this country. We can agree to that. But ever since Section 5 was struck down in 2013, our conversation has been about how do we reauthorize the Voting Rights Act? And now that Section 2 is under fire, everyone's like, okay, what now? But it is also true that there haven't been a ton of successful Section 2 cases in the last 40 years, right? And even if we reauthorize the pre-clearance provisions of the Voting Rights Act, Section 4B and 5, we also know that whether or not that's enforced wildly depends on who's in power. And so it's like we ignore those things, and instead we focus on the fact that we really need, this legislation to do these things. But we don't have hard conversations about whether or not this legislation can actually meet the moment. So I think we need to do something else. The problem is that I don't know what that is. And I am honest enough to admit that, right? I know that reauthorizing the Voting Rights Act probably is not enough, given the challenges that we face as an inclusive democracy, to be an inclusive democracy, right? Because it was also true that Section 2, as if Section 2 gets struck down, I will have a visual and be sad just like everybody else. But it is also true that it was very difficult to win, given how the Supreme Court had interpreted Section 2 in recent years.
So who gets the power then? Like where would you look for fixes?
So part of the fix has to be, and so let's be clear. I think, and Terry, I'm gonna take a slight modification of your question.
Sure.
Where do you look for fixes when we don't all agree that we should live in a multiracial, inclusive democracy? We don't even agree on first principles. So, given that, I think that the solution has to depend on where you live. I never thought I would say, gosh, federalism can be really good in this circumstance, but it actually can, right? Because we talk about federalism, at least we used to, as, well, we'll let states experiment, and then, the Congress can sort of take the best practices of the states and think about that in terms of nationalizing certain aspects of election administration. That was the bill from, 2019, 2020, HR 1. I think it was HR 1. HR 4 was to reauthorize the Voting Rights Act. That was HR 1 a few years ago, right? It was kind of like taking pieces of different practices and trying to figure out what makes sense on a national stage. And so I wonder if federalism is the answer here. Federalism in the sense that those states that are still committed to this idea of inclusive democracy, that they take control of their systems and try to figure out what makes sense for their voters within certain constitutional constraints. So not falling below certain constitutional thresholds, but definitely pushing the ceiling upward in terms of what we can do in order to make sure that people can participate. Now, I don't love this as a solution because I do think that it leaves, a good chunk of the country behind. But you do have to wonder about Congress. If Congress has been silent on governing for the last 10 months, essentially, they're not all of a sudden going to wake up and say, we're going to use the power that the Constitution has given us, that has lain dormant for over a century, in order to make voting more inclusive. Right? It's just not realistic and not pragmatic. Now, if we get a Congress like that, then I definitely think it could be some combination of, pro democracy states laying out rules to ensure participation. And then Congress, again, taking best practices that it then nationalized, because I do think that there has to be a shared sentiment and commitment to democracy in this country in order for it to move forward. But where we are now with our levels of polarization, it's really hard to think about solutions on a national stage that have any hope of ever going into effect.
Franita, what do you think is the biggest threat to voting rights in a post Louisiana v. Kelly world? Is it in the realm of election administration, or is it something in redistricting? Where do you see the echoes of history reverberating most loudly in 2025?
It's the idea that the rule will become that racial gerrymanders can be justified for partisan political purposes. Right? Like, I think we know that, but have we really internalized that? Um, to me, the shocking thing is, so we have that pronouncement, but it is also sort of the rules that make that the case, right? So the idea that there has to be a presumption of good faith towards the legislature when they're trying to gerrymander a racial minority out of existence, right? So it's almost insulting, right? This notion of let's even go with appearance of fraud, right? So this is all a way of the Supreme Court basically saying that it's just rational basis review. And when we're talking about basic rights here, right? Like at least, post 1960s, would comfortably say that the right to vote was is a basic right in this country. But the rules that the sub doctrines that the Supreme Court has come up with in the last few years basically equate to rational basis review of anything that has to do with, voting rights, gerrymandering, even election administration. But it's election administration if Congress does it, right? So there's more stringent review of anytime Congress tries to regulate in this space and absolute deference to the states. But I don't think that that is necessarily universal. That's another, to take it back to Terry's question. Even if we say that, democracy states have wide room and latitude to experiment and do different things, if they face challenges, it's not certain that the Supreme Court would actually side with them, right? So even then, we come back to this question of what can you do in this space? Now, a part of me loves the idea of taking negative case law or precedents that I don't agree with and turning them on their head for something good. But I wish I had more faith that there will be consistency in the Supreme Court about how they approach certain doctrines in certain situations, regardless of who's bringing the challenge. And I don't know if I feel that confidence, if I'm being honest.
You mentioned the big, HR1 bill that Democrats in Congress wanted to push through primarily after Biden won and came into office in 2021, and the Democrats had the House and the Senate, but they didn't have a filibuster-proof majority in the Senate. And so there was an effort by some Democrats to get rid of the filibuster, but a couple other Democrats refused to go along, and so that law failed. At the time I wrote
Their
a couple.
names. Say
What?
their names, Ed. Kristen
Yeah, well,
Sinema and Joe Manchin.
it was Sinema and Joe Manchin. Although the scuttlebutt is that they took the cover that there were another 5 Democrats who were very happy that Sinema and Manchin took the heat for that because they didn't have to. But that if
I would
they
say their names too if I knew them.
Yeah, I don't know them. I've heard some rumors, but nothing that's I think worth saying in this podcast. But uh, but in any event, one of the questions that I have looking back on that recent history, for strategic reasons, if nothing else, is to say that rather than attempt to go really big and have that 800-page law that covered everything from absentee voting, like you said, it was like picking best practices as the Democrats saw it, early voting here, absentee voting there, voter registration, et cetera, et cetera. Whether or not there could have been a congressional law that just targeted the gerrymandering problem. And my reasoning for that was that the Senate isn't gerrymandered. Uh,
Hmm.
right. And so you needed to get 60 votes to break the filibuster in the Senate. You had 50 Democrats. You had 7 Republicans who voted to convict Trump. You needed just 3 more Republicans to say, for the sake of democracy, post-insurrection, we at least have to get rid of the cancer of gerrymandering. The House was controlled by the Democrats, so they were already on board with anti-gerrymandering laws because it was part of the 800-page bill. So I'm wondering if the lesson to be learned is if there's ever an opportunity again to use congressional power, it should be used strategically for the worst cancers on our democracy, like gerrymandering, as opposed to trying to go big and do everything all at once. Do you have a reaction to that or
I think it depends on what the level of polarization is at the time that they attempt this. Because I mean, there is a historical lesson for incrementalism. So if you look at even the Voting Rights Act, right? The in 65, I don't think it touched literacy tests. It wasn't until the amendments in 1970 that it was extended to literacy tests. Right. So you had amendments in 1970, 1975, 1982. Right. So, and this was, and this was after we understood one, how the Supreme Court would interpret the law, but also how the law applied on the ground and whether there was holes that needed to be fixed. So there is some lessons there, I think, that could support this idea that we go after the worst cancers first, and then maybe come back later and figure out if there are other changes or other things that we need to do in order to improve our system of democracy. So I'm not opposed to that at all. Um, but I do wonder, and one thing I would love to see more, I would love to see more of a partnership between the states and the federal government. Right. Because, one of the things that I've been thinking about in trying to get ready to write this volume 2 on the 20th century is, to what extent have states really been able to capitalize on this idea of federal government as big brother telling us what to do, despite us having a say in, something that the Constitution, as the Supreme Court has interpreted as, gives us broad authority, right? Like this idea of the federal government just doing whatever it wants to do and states just being conquered provinces, a la, Reconstruction. That's a very powerful narrative that the Supreme Court has really pushed in interpreting the Voting Rights Act in the last 20 years. And so, if there's more of a political partnership between the states and the federal government in this space, and it takes the wind out of that particular narrative, I think we can actually get more done. And I also think that there are a lot of synergies that the states and the federal government might agree on if they're both in a pro-democracy space, right? So more collaboration, more understanding, I think could go a long way because the collaboration and understanding that tended to exist in the context of the Voting Rights Act actually didn't get a lot of attention. There was a wonderful piece written. God, I wish I could remember his name because it really was brilliant. This professor he was at Syracuse. I think Syracuse, Buffalo. He was at Buffalo.
Jim
He was
Gardner, maybe?
no, but he
Oh,
was there with Jim Gardner though. He was an
oh,
election law person. He was there for a little while, but he wrote a piece where he talked about the level of conversation that happened in the context of the pre-clearance requirements. How sometimes the pre-clearance requirements actually became kind of pro forma because states would just be in conversation with the federal government about changes that needed to be made. Most things did not go to litigation. Most things did not get a lot of public attention, and it really was this level of cooperation between the states and the federal government when it came to complying with the requirements of Section 5. But the Supreme Court completely overlooked that, of course, right? Because they're focusing on the bad actors who get preclearance denials, every redistricting cycle. Texas. So, if we are in a position where it's kind of a clean slate and we can have a conversation about what regulation in this space should look like, it definitely should be something where the states and the federal government are in partnership and in conversation, because I think that'll go a long way towards getting rid of this narrative that the federal government is stepping on the states' toes such that it offends their sovereignty.
Well, I have one question that will switch gears a little bit. So,
Okay.
Carrie or Tony, if you want to kind of stick with the book or stick with this theme, and anything else you guys want to add?
I was just going to add, Bernita, one of the things that I find so striking about the last decade or so Supreme Court rulings that have essentially said it's okay to use race as a proxy for party if your motivation's partisanship. Um, the 15th Amendment was adopted in response to the use of race as a proxy for party, since, of course, African Americans were virtually 100% were voting Republican in the
Yeah.
South, and whites were voting overwhelmingly for the Democratic Party. So I wonder in your book if you explore the role of partisanship in the 19th century South as well as race.
So I do, but I think a surprising part of the book is I talk a lot about that prior to the Civil War, right? So I talk a lot about partisanship as a motivator in whether or not Congress exercised authority that it had under the Constitution to regulate elections. Because I wanted to challenge this federalism narrative, right? That Congress would stand its hand because it was concerned about state sovereignty. And in a lot of situations, Congress would stand its hand prior to the Civil War because of political reasons, or it was acting because of political reasons. So in the 1850s, when you had all of the dust up about slavery, and you had Dred Scott and the Kansas-Nebraska situation, Congress became way more aggressive about policing elections. And so, that was political, but that does not mean that power all of a sudden existed in the 1850s, right? Like, if you buy into this narrative that, Congress is so concerned about state sovereignty, then Congress would have stayed just as silent in the 1850s as it had been in the 70 years before, right? So you had these political dust ups where Congress was willing to be aggressive in using its power under the Constitution in order to, for partisan gain. Another situation where that was the case was with respect to the Reapportionment Act that was passed in the 1840s. Right. So the adoption of single member districts was actually quite controversial because that was a decision that had, up to that point, been left to the states. But for the first time in our country's history, the Whig Party had control of both houses of Congress and the presidency. And they decided that they wanted to try to secure that majority. And they did better with single member districts. And so it really was an instance where you had this incredibly partisan legislation that really indicated that the things that we assume are based in federalism, i.e., Congress is also concerned about state sovereignty, so it won't act, was actually about, politics. So to me, the book it's interesting in that sense because I do think the race versus party conversation pretty squarely fits in treatments of Reconstruction and sort of Reconstruction policy. But I don't think we understand the extent to which that party question also predated the Civil War, such that by the time we get to Reconstruction, it had actually become more complex, right? And Congress thinking about, do we care about state sovereignty? Can we do that? Oh, yeah. Most of our Black supporters are Republicans.
So, talking about Reconstruction and talking about the relationship of federal power and state power, I'd love to hear your thoughts looking ahead to the next year's midterms. And I'll tell you why I'm concerned. I'll just put my cards on the table. I'm sure Franita, the 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 concerns about the possibility of the federal government actually abusing power pretextually by trying to interfere with how states run their elections to manipulate, distort the process. And now I'm not talking about gerrymandering now. I'm talking about, using ICE agents or other federal agents at polling places to intimidate voters. I'm talking about the possibility of the federal government seizing ballot boxes and not letting the votes be counted. I mean, these are hopefully, parades of horribles that will never actually come about. Um, and a lot of other people are concerned about this and think, well, the federal government doesn't have power to do that because elections are run by states. And so there's just no possibility that a president of the United States can order the Justice Department to do this, that, or the other thing. And yet, having talked to you for years and years now and knowing your work leading up to the book, the story is more complicated than that. And you have, the Grant administrations, or the two Grant administrations in particular, thinking about the use of federal power after the Civil War and after the adoption of the 15th Amendment. And I'm just curious, what your thoughts are about the relevance of that Reconstruction related history. What we should know about that in terms of preparing, for hopefully an election next year that is free and fair and that's appropriate and that isn't interfered with improperly. Any guidance or thoughts you can give us on that?
I think since the last election, one of my concerns in publishing this book was, so keep in mind the narrative. The narrative is, hey, Congress, you have all of this power that you don't use. And the book doesn't necessarily have a judgment about whether or not Congress should use the power, right? Like I intentionally stay away from what's going on now. Or in fact, I stay away from anything that has happened really in the last 100 years. The book ends in 1911. And it's very purposeful because I do think that there's a lot of things that happened over the preceding 150 years that complicate the lessons that we can draw from Reconstruction, right? So it's not, to me, you look at Reconstruction and you look at now, it's not an apples to apples comparison. But the book spends a lot of time talking about Congress's power under Article 1, Section 5 and how underappreciated it is. And, I try to be very intentional about emphasizing the fact that Congress, even in using this power to judge the elections of its members, still had rules. There may have been rules that Congress itself developed, but there was still some sense that there should be some structure to this process so that we can make sure that, if we're going to disqualify somebody for the seat, that it's legitimate. Right. So, you had, and there were, don't get me wrong, the decision sometimes of whether or not to even entertain a challenge was partisan. Right. Sometimes they would sit on things for 2 years and then they would decide that the Democrat won. And, at that point, they've already had an election where the Republican will be seated the next Congress. Right. So some of this was partisan. But I think my fear is that people will look at that history and they will say, OK, now we can challenge races where, someone from a political party we don't like has won and refuse to seat them. Right. Because, the interesting thing about the early contested elections under Article 1, Section 5 is that the Congress was actually not aggressive in determining what the Constitution means in that context. Right. So that there were some state court decisions where they would try to follow the state court. If the state court hadn't weighed in on whether or not a particular voting restriction was constitutional or not, then Congress would weigh in. And if the Supreme Court had weighed in, Congress would usually follow the Supreme Court in that context, right? So there was some variation, but there seemed to be sort of this still like somewhat deference to the court, although Congress did give itself space in how it constructed its rules and how it dealt with situations that were not clearly covered by case law, and also how it dealt with its own precedents, right? There was later cases that looked to a contested election that had determined that the 1882 South Carolina voter registration law was unconstitutional. Congress decided that, and they looked to that earlier contested election and applied that as precedent in a later case, right? So Congress had its own rules, but there still seemed to be some respect for the courts even in that space. Now we're kind of living in a different world, right? We're living in a world where the presidency is the branch where you see a lot of law being made. And so there's a question of if Congress says, okay, we're going to start entertaining contested elections under Article 1, Section 5, and you have a series of executive orders that weigh in on the constitutionality of various election practices in the states or try to impose certain restrictions, even if it goes beyond the purview of what the federal government can do in this space, and you have a Congress willing to treat that as law, I think that, That's why I said it's not apples to apples. It's, to me, looking at Reconstruction doesn't tell us what to do in that particular situation. And it's very much a situation that we could face next year.
That's interesting. Yeah. I think it is important. The respect for history shows that you can't just dump it. You can't just take the history and dump it in the present and think it's going to solve your problems.
Yeah.
Yeah. Tony, sounds like Tony, you were about to say something.
Yeah, the thing that I keep coming back to is just how it's interesting. Franita has just written a work of scholarship on a critical moment in American history, and yet here we are in 2025, which in so many ways is unprecedented. It is, as far as at the national level, it's the parallels with the South, I think, in the late 19th century are clear, but the level of threat and challenge to democratic norms, even just rhetorically, is something I struggle to think of a historical precedent that's really on point. I don't know if you agree with that, Franita, what your thoughts are, but for me, we really are in so many ways in uncharted terrain.
I think it goes to the saying that history doesn't repeat, it echoes. So I don't know if we'll find a perfect example, but I definitely think that there are lessons to be learned from the times in this country in which America was not a democracy. We've romanticized democracy in the last 50 years, such that I think a lot of us do not understand that it is actually being challenged right now because we just assume that it'll always exist. And given the fact that we are the world's oldest democracy, and there are things in this country that are not as old as some of the other countries in the world, right? Like you go to Great Britain, there's things that's older there than even exist in this country, or go to India or there are a ton of countries where their history it extends far beyond ours. Yet we are the world's oldest democracy, and that tells you something about the fragility of democracy. Yet we assume that it is something that will continue to exist, and that just baffles me. In part, maybe because I study this history and I know that there are times in which America has not been that. And in fact, America has not been a democracy for much longer than it has actually been a democracy. And so to understand that in this moment we could lose it, I think is a point that's lost on a lot of people because in the last 50 years, we have conditioned ourselves to believe that it's something that will always exist. And I don't know if the lessons of history are sufficient to scare people enough to realize how fragile it is. One of the stories that I like to tell my students is about the insurrection in Wilmington, North Carolina in 1898, where a group of white supremacists overturned a duly elected government there. And nothing happened. They just, 300 people died. They overturned the government and they took over, and life went on. The federal government didn't do anything. And, they kind of had a reckoning maybe, 120 years later after this event or whatever. But it was a situation where democracy died and nothing happened. And I don't think people understand how susceptible we are to that state of affairs. And I think January 6th, so one of the reasons why I think about Wilmington 1898 is because of January 6th, right? And the fact that we came so close nationally to seeing something that had happened in a small region of the country. But even with that, I don't think people fully have fully internalized the fact that, in the next few years, American democracy could be a thing of the past. And we all live here, but we live here in nothing that resembles a democracy.
Well, that's sobering. I mean, you refer to, people do talk about America as being the world's oldest democracy, but if I take your point, and I think it's a valid one, we didn't really become a democracy until the Voting Rights Act of 1965. I mean, there were pieces there that we could, build upon, but it wasn't. Thankfully, we developed a robust sense of democracy, I think, by the 1960s. The combination of the Voting Rights Act and the one person, one vote doctrine and the Warren Court and other changes meant that the national mindset starting in the 60s was we really did believe in genuinely universal suffrage and an inclusive democracy, or at least that we professed to believe those ideals. and tried to do something to implement them.
Actually,
But
Ned, I think it's that, and this is an important modification to your statement. I think it's some of us believed in it, right? Like one of the reasons why we're in this situation now is the fact that there has always been a critical mass of Americans, a critical mass of Americans who don't necessarily endorse democracy.
yeah, fair. No, fair. I mean,
Right? Like this is, and then they come to power, and the rest of us have to kind of figure out how to navigate that space. But one point I was trying to make is that I think we got lulled into complacency over the last 50 years because I think you're right. The 1960s was like this high water mark when we were able to really get a sense of what it meant to have broad participation. And we ignored that there were still elements in our society that didn't endorse that.
I have to think that any democracy is going to have some subset of its population that is not on board. I mean, again, I'm no expert in post World War II Germany, but as Germany transitioned from Nazism to post-Nazism, it wasn't like every German suddenly repudiated Nazism who believed in it, prior to that. So a democracy has to be able to sustain itself if enough people believe in it, even if a subset doesn't. And so I guess what I'm asking in this regard is, do you think the percentages have changed relative to the 60s, or have, what, to the extent that we are backsliding from that high water mark, what's causing the backsliding? Is it people that who were on board or no longer on board? Is it that a younger generation is not do you have a sense of of what's responsible for the backsliding?
That's such a complicated question there, right? Because there are a lot of reasons why. First, the backsliding is inevitable in some sense, right? Like I think there's always the pendulum always swings back in the other direction. The question is, for me is, as the pendulum swings, are we creating policies that take into consideration the fact that everybody's not on board? And I don't necessarily think that we did, and I'm not comfortable in saying in hindsight that we should have did X, Y, and Z, because I do think, for example, the Voting Rights Act did the thing it was supposed to do, right? But then there's a question of whether or not we needed other policies to work in concert with the Voting Rights Act so that the people who were not the beneficiaries of that act did not feel like they were being left behind politically, right? Because it's very easy to see Shaw versus Reno as a response to the success of the Voting Rights Act and the fact that politicians were starting to take advantage of the fact that they can manipulate Black and brown voters in order to translate that into meaningful political power. And then white voters saying, wait a minute, right? Like, did have we ever been in a situation where you have a success, but the success creates resentment from certain corners, and we think about that resentment ahead of time instead of in retrospect? I guess is my question. And I don't know if we do that well, right? We in our country, in writing this book, it always has been like the haves and the have-nots, right? Think about the Reconstruction conversations about women's suffrage, right? As soon as women perceived that the 14th and 15th Amendments would be about the enfranchisement of Black men, then all of a sudden you really have very clear sort of racism and xenophobia and all these other things in that movement because now they see themselves in opposition to African American suffrage, right? And so when we have legislation, are we sufficiently thinking through the fact that one day the pendulum will swing in the other direction, where you do have these elements that have felt marginalized? Now they have political power, and now they are invested in this idea that they can't win unless you lose. One of the nice things I thought, and maybe I was, I don't know, too optimistic, too naive, I don't know. I always thought about, being a democracy scholar. One thing that is key to any concept of democracy is this idea that a rising tide lifts all boats. And you kind of focus on that. Not, but I think in my focus, even I have ignored the fact that, so much of society is framed as winners versus losers, us versus them, such that when you're making policy, you have to take that into consideration. And that's part of the reason why I don't think it's enough to just say we need to reauthorize the Voting Rights Act. It's as we build an inclusive democracy, what are the policies that we need to focus on so that no one feels left behind? And that might just be too aspirational. But I do think it has to be an aspiration. Otherwise, we'll just have a situation where someone else comes to power. They'll focus on trying to fix some of what's broken. And then eventually, before we can get to where we need to be, the pendulum will start moving back in the other direction. And it'll be 2025 again.
So what do you think, Terry and Tony? Do you think we've had a great conversation? Franita, any sort of final words you want to share with us as we wrap things up?
Buy my book.
Absolutely. And it's available for need from Cambridge University Press.
It's
Is that
coming out
correct?
on Cambridge. Hopefully end of next summer, early fall. That's what I'm hoping. It'll definitely be out before the election.
Maybe we can interview you again when it comes out.
Yeah, that'll be fun. That'll be fun. And I'm also planning like a little book tour thing. So maybe I can come to Ohio State and be in conversation with you and your colleagues about it.
Oh, that'd be great. That'd be wonderful.
Absolutely.
But yeah, I think that, history illuminates. It doesn't provide all the answers. And so the goal of the book is really to give people a different perspective about what was happening. But I was very careful I didn't want to bias people one way or the other. So Congress is not necessarily the good guy in this book. That's hence the question mark. But I do think it complicates the narrative that the Supreme Court really endorses as it strips Congress of its authority to be proactive in the democracy space.
Well, on behalf of Terry, Ned, and all of our Election Law at Ohio State colleagues, I'd like to thank you, Franita, for a wonderful discussion of your book and an important and sobering discussion of the state of American democracy today.
No, thank you. This was awesome. Makes me a little nostalgic for the free and fair days.
Okay, well, we'll just get you back as often as your schedule permits.
Sounds good. Thanks so much.
Thank you, Franita. I'd like to remind our viewers to please like and subscribe to our YouTube channel and look forward to our next podcast.